You still haven't told me why you pulled me over, Sheriff.
Ma'am, vehicles like this are often flagged for theft. Just need to verify ownership.
Flagged for theft? I've driven this car for 3 years. It's in my name.
That may be, but someone in your situation driving a car like this raises questions.
She had left home that morning of February 14th, 2025, with the same routine as any other work morning. She had had coffee, had checked the day's schedule on her tablet, had picked up the folder with the documents she would need at court, and had walked out the front door of the house where she lived in that residential neighborhood, with its large homes and leafless February trees against the blue sky of a cold morning. The car she had gotten into was white, was luxury, and was hers, purchased with 23 years of a career in a profession that rewards decades of competence with the kind of financial stability that allows certain choices. She had started the engine, had put on her seatbelt, had pulled out of the residential street toward the highway that led to the courthouse where she had worked for 8 years. It was an ordinary Tuesday morning. There was no reason for it to be anything else. And then the lights of a police cruiser had appeared in the rearview mirror. The officer's body camera had begun recording before he reached the driver's window. This was visible in the timestamp, 10:42 in the morning, on a day in February 2025, and had captured the agent's approach to the white car with that specific image quality that body cameras produce when winter sunlight hits metallic surfaces, slightly overexposed, with colors mildly flattened, but with enough clarity that every detail mattered. What the camera had captured when it reached the height of the driver's window was a middle-aged black woman in a royal blue blazer and gold necklace with her right hand still on the steering wheel. Looking at the officer with that expression, anyone who has ever been stopped without reason immediately recognizes the expression of someone who already knows what is happening before a single word is spoken, and who is calculating in real time how to respond in a way that does not worsen a situation that should not be happening. The woman sitting in that white car was named Dr. Catherine Morris. She was 52 years old, had been appointed federal judge 8 years earlier after a career that had included 15 years as a public prosecutor and 6 years as a constitutional law professor at a university whose name appeared on the country's best law schools lists. She had been appointed through a process that involved Senate review, had been confirmed by vote, and exercised jurisdiction over a federal district covering a considerable geographic area, with a population that included the neighborhood where the officer had turned on his cruiser lights behind her car that February morning. She had spent 8 years applying the law with a precision that attorneys who appeared regularly in her courtroom described in terms that consistently converged around two characteristics: that she was rigorous with evidence, and that she treated everyone who appeared before her with the same demands and the same respect, regardless of who they were. On that February morning, a police officer had decided she needed to prove who she was before she could continue on her way to work. The officer had said there was an irregularity with the vehicle's license plate. That had been the initial justification, though a license plate irregularity, communicated with the technical language officers use when they need an articulable reason for an approach and choose the vaguest available criterion. Catherine had heard that, had looked at the officer with the expression the camera had captured, and had done something the camera had also captured, and that any attorney or judge would immediately recognize as the behavior of someone who knows the process that is about to happen. She had become very still, had kept her hands visible, and had begun processing every word with the attention of someone who knows that every word being said and every word being answered is being recorded, and that recording will matter. If this is your first time on this channel, welcome. What that body camera captured on that residential street in February 2025 is one of the most extraordinary recordings this channel has ever analyzed, not for the rarity of what happened, but for the specific identity of who was sitting in that car, and for what that identity revealed about how the system fails, even the people who were placed inside it, to ensure it does not fail. Hit subscribe right now and tell me in the comments, do you think a federal judge should have to prove who they are to an officer in an unjustified stop? Tell me down below. The license plate irregularity that had been cited as the reason for the stop would be verified during the subsequent process, and the result of that verification would be one of the most cited elements in legal analyses of the case in the weeks that followed. There was no irregularity. The plate was correctly registered, the vehicle registration was current, the insurance was active, and there was no pending issue of any kind. associated with that car or that plate in any system the officer could have consulted before turning on his cruiser lights. What there was a white luxury car being driven by a black woman in a residential neighborhood of large homes on a Tuesday morning, and the camera had captured the approach that combination had produced with enough clarity for the entire world to watch and draw its own conclusions about what had motivated those lights to appear in Catherine Morris's rearview mirror on that Valentine's Day morning. The officer had arrived at the driver's window with that posture body camera's capture with a fidelity that human memory rarely manages to replicate. The posture of someone who had made a decision before getting out of the car and was implementing that decision with the specific confidence of someone who does not expect the decision to be questioned. He had asked for the driver's license and vehicle registration with the tone of someone making a request that presumes immediate compliance. Catherine had opened the glove compartment with deliberately slow and visible movements, had removed the documents, and had handed them through the window with her right hand, while the left remained visible on the steering wheel. That gesture, of keeping the left hand visible while moving the right, was the gesture of someone who had learned, through a combination of legal training and lived experience, that every movement in a police stop has the potential to be interpreted, and that the interpretation can have consequences the movement itself does not justify. The officer had examined the documents for a time the camera had captured as longer than necessary to verify the validity of a driver's license and vehicle registration document. During that time, Catherine had kept her hands on the steering wheel looking forward, and the camera had captured that profile of her. The blue blazer, the gold necklace, the upright posture of someone containing a reaction, while simultaneously processing what is happening and what they will do about it. Other cars had passed on the residential street during that time, some slowing slightly when passing the cruiser with its lights on, the kind of deceleration drivers make when they see a police stop, and that is simultaneously curiosity and caution. None of those cars had stopped. The scene had happened with that quality of public visibility and simultaneous invisibility that defines many of the situations this channel examines. The officer had returned the documents and had asked a question the camera had captured with enough clarity to be transcribed word for word. He had asked what Catherine was doing in that neighborhood. He had not framed the question in any operational context. He had not said there was an incident in the area, or that there was an ongoing search or any other reason that made the question functionally connected to any legitimate policing objective. He had simply asked what she was doing in that neighborhood, with the specific tone of a question that presupposes that the person being asked needs a reason to be where they are. Catherine had responded that she lived in that neighborhood, had pointed in the direction of the street she had left a few minutes earlier. The officer had looked in the direction she had pointed, with an expression the camera had captured, and that anyone watching would describe as the expression of someone who has received information they had not anticipated, and who is still deciding what to do with it. It was at that moment that Catherine had said something the camera had captured, and that had initiated a second phase of the interaction that was qualitatively different from the first. She had said, with that calm the camera had recorded, as the calm of someone who chose each word carefully before opening their mouth, that she was a federal judge and that she needed to know what the legal justification for the stop was because she had not committed any traffic violation and the car's documentation was entirely current. She had said this not as a threat or as intimidation, but as information, the same way any citizen has the right to ask for the justification of a police stop, with the difference that Catherine knew, with a technical precision, that few citizens possess exactly what the law required as the basis for that stop, and exactly what the absence of that basis meant legally. The officer had been silent for a moment after hearing that. The camera had captured that silence with the same fidelity with which it had captured everything else. The mention that she was a federal judge had produced in the officer's behavior a change the camera had documented in enough detail that anyone watching could identify the exact moment it occurred. It had not been a dramatic postural change or an immediate verbal reaction. It had been a subtler change in the speed of subsequent responses, in the frequency with which the officer's eyes had gone to the camera on his own chest and returned to Catherine, in the slightly different quality of the tone he had used in subsequent sentences compared to previous ones. It was the change of someone who had received information that altered the situation's calculation, but who had not yet completely decided how to integrate that information into what they were doing. Catherine had observed that change with the attention of someone who had spent 8 years observing how people behave when processing new information in a context of pressure, which was essentially what happened in a courtroom every day, and had continued waiting with her hands on the steering wheel. The officer had asked Catherine to wait and had returned to his cruiser. He had been in the cruiser for 9 minutes, according to the body camera timestamp that had continued recording throughout that time. During those 9 minutes, Catherine had stayed in her car with the engine running and had done something the camera had not captured because it had happened inside the vehicle, but that she would later describe with a precision that made the scene completely visible without any image. She had picked up her phone, had opened the Notes app, and had begun typing. She had typed the cruiser number she had seen in the rearview mirror when the lights had appeared. She had typed the time. She had typed the exact street. She had typed every word of the interaction up to that point that she could remember with enough precision to trust. And she had typed the question the officer had asked about what she was doing in that neighborhood in quotation marks, because that specific question had been sufficiently precise in its inadequacy to merit exact preservation. The officer had returned from the cruiser after 9 minutes with a change in posture the camera had captured, and that was different from the posture with which he had first arrived at the window. There was in him now something that was not exactly retreat, but was adjacent to it. The posture of someone who had made a consultation during those 9 minutes that had produced enough information to alter his assessment of the situation without him having yet decided how to articulate that alteration. He had told Catherine that the plate had been verified and that everything was in order. He had said this without mentioning what the verification had found or failed to find, without explaining why a 9-minute verification had been necessary for a document that was completely regular, and without answering the question Catherine had asked before he returned to the cruiser, the question about what the legal justification for the stop was. Catherine had noted the absence of that answer with the precision of someone who had spent 8 years in a profession where the difference between what was said and what was asked was frequently the most relevant element of any interaction. She had asked the question again, not aggressively or with the tone of someone looking for a confrontation, with the same calm that had characterized every moment of the interaction up to that point, and that the camera had captured as the calm of someone who had made a decision about how to behave before the stop began, and who was maintaining that decision, regardless of what was being said or done around her. She had asked the officer to describe the specific traffic violation or observable behavior that had motivated the stop, because without an answer to that question, the stop had no legal basis, and she needed to understand whether what had happened had been a mistake or something different from a mistake. That specific formulation, the distinction between a mistake and something different from a mistake, had been captured by the camera and had been analyzed repeatedly by legal commentators in the weeks that followed as an example of language that was simultaneously precise in its technical meaning and absolutely clear in what it was communicating beyond that technical meaning. The officer had responded that he had thought the plate appeared irregular when he had passed the car. Catherine had asked what specifically had appeared irregular. The officer had said the angle had seemed different. Catherine had been silent for a moment after hearing that, a silence the camera had captured and that anyone who had watched a trial would recognize as the silence that precedes an observation that will be precise. She had said that license plates had angles because they were mounted on brackets that had angles, and that her plate's angle was the standard factory installation angle that had been there since she had purchased the car. She had said that and then had been quiet again, leaving. The officer's response to occupy the space she had created. The officer had not filled that space with anything the camera could record as a substantive response. There were other houses visible in the camera's background throughout that entire interaction, the large homes of the residential neighborhood where Catherine lived, and where the officer had decided that a white luxury car driven by a black woman justified turning on the cruiser's lights. That framing detail, the neighborhood in the background, had been noted by several of the commentators who had analyzed the video when it became public, because it added a layer of context to the scene that made the question about what Catherine was doing in that neighborhood even more revealing than it already was. She was not in a different neighborhood from her own. She was on the street she had left that morning, on her way to work, in a car she had purchased, in a neighborhood where she had been paying property taxes for years. The question about what she was doing, there was a question about the right to presence in a space that was specifically her space, and the camera had captured that question with the houses of that space visible in the background, with a documentary completeness that no screenwriter could have deliberately constructed. A second officer had arrived during the interaction, dispatched by the first after he had returned from the cruiser, and had parked behind the original cruiser with its lights also on. The arrival of the second officer had been captured by the first's camera, and had added an element to the scene that attorneys who would analyze the case would describe as disproportionate escalation, because the stop of a supposedly irregular license plate, which had been verified and had resulted in nothing, had produced two cruisers on a residential street with lights on a Tuesday morning. The second officer had stayed beside his cruiser, observing the interaction without approaching. Catherine's car, a position the camera captured in the background, and that had the visual effect of making the scene larger and more formal than any available justification could explain. Catherine had looked at the second car in the mirror and had returned to looking at the first officer with that expression the camera had captured from the beginning, and that had not changed throughout the entire interaction. She had said she was going to need the officer's full identification number and the stop report number because she was going to file a formal complaint. She had said this not as an ultimatum, but as information about what was about to happen, the same way she had said she was a federal judge, as relevant data that the other party in the interaction had the right to have. The officer had provided the information. Catherine had typed it into the phone, which still had the Notes app open from the period when she had been waiting in the cruiser. And she had put the phone back in the cup holder, had placed her right hand back on the steering wheel, and had waited for the officer to say whether she was free to go, because she knew she needed to hear that explicitly before putting the car in motion, because the camera needed to capture that moment too. Catherine had arrived at the courthouse 23 minutes late that morning of February 14th. She had parked in the space reserved for judges, had picked up the folder with documents from the back seat, and had entered through the court personnel access with that posture that people who worked with her described as her posture on any day, upright, direct, with no external sign that that morning had been different from any other morning. The hearing that had been scheduled for 10 had been rescheduled for 11 by the court clerk when it became clear Catherine would not arrive on time, and the attorneys who had waited in the hearing room had been informed only that there was a delay without additional explanation because Catherine had instructed the clerk to that effect when she had called from the car during the 9 minutes she had waited for the officer to verify a plate that had no irregularity. She had conducted the day's hearings with the same precision as any other day. The attorneys present that morning had not noticed anything different in Catherine's behavior during the hearings, which was itself a relevant data point about the specific quality of control she had exercised over that morning's experience. The capacity to enter a courthouse after having been stopped without justification on her own street, and to conduct hearings with the objectivity the function required without letting one experience contaminate the other. It had been only at the end of the day, after the last hearing had concluded and the court staff had left, that Catherine had sat in her chambers and had made the calls she had decided to make since that moment in the stopped car when she had begun typing in the Notes app. The first call had been to the county police department director, not to a subordinate or to a service line, but directly to the director, whose direct number Catherine had because she exercised jurisdiction over cases involving that department frequently enough for the direct number to be operationally relevant information. She had described the incident with the factual economy of someone who had spent decades doing exactly that, identifying the relevant elements of a situation and communicating them in the sequence and with the level of detail that made the situation comprehensible without unnecessary embellishment. She had given the officer's identification number, the cruiser number, the body camera timestamp she had discreetly consulted during the stop, the question about what she was doing in that neighborhood with the exact words she had typed in the Notes app, and had said she expected the body camera recording to be preserved and that it would be available when formally requested in the days that followed. The director had listened without interruption, had asked 2 questions at the end, both factual, about the exact time and location, and had said he would verify personally. That commitment to personal verification in a call received at 6 p.m. on a business day had been the first indicator that the department had made an immediate assessment of the seriousness of what had been reported and had decided that the appropriate response was personal and direct rather than delegated. The second call had been to an attorney specializing in civil liability of public agents with whom Catherine had worked in prior cases in different capacities and who had answered on the first ring when he had seen her name on the screen. He had listened to the account with the attention of someone simultaneously evaluating what they are hearing as a story and what they are hearing as a case, and had said at the end that the element of the question about what she was doing in that neighborhood was, in his words, the element that transformed a documentable discriminatory stop into a documentable discriminatory stop with intent stated out loud and captured on camera. The department had initiated an internal investigation the following day, which was a response speed that those who followed police conduct cases described as unusual, and that had been attributed to two factors that rarely coexisted in a case of that kind. The first was Catherine's identity, because a formal complaint from a federal judge about a state officer's conduct created an institutional dynamic that did not exist when the complaint came from a citizen without institutional position, not because a complaint from a citizen without position should carry less weight, but because the operational reality of departments was that complaints from people with institutional power produced faster responses regardless of any formal policy about equal treatment of complaints. The second factor was the body camera, which had been recording since before the officer reached Catherine's window and had captured every moment of the interaction with a completeness that made any alternative version of events impossible to construct credibly. The internal investigator who had been assigned to the case had watched the complete recording on the first day of the investigation, had prepared a complete audio transcript, and had identified 4 specific moments he had marked as priority analysis points. The first was the initial stop, which the recording showed had occurred without any visible traffic violation or observable behavior that could have motivated the decision to turn on the cruiser lights. The second was the question about what Catherine was doing in that neighborhood, which the recording captured with enough clarity to be transcribed and that had no articulable connection to any legitimate policing objective. The third was the license plate angle justification, which had been presented after 9 minutes of verifying a document that had no irregularity and that the investigator had described in his notes as the weakest justification he had encountered in a stop report in 18 years of internal investigations. And the fourth was the arrival of the second officer, which had escalated police presence in a situation that had not justified the presence of the first. The video had become public 12 days after the stop, not through any action by Catherine or her attorneys, but through a public records request made by a reporter who had received a tip about the incident from a source inside the department who had watched the recording during the first days of the internal investigation and had made the decision that people inside institutions sometimes make when they see something they believe the public needs to see. The request had reached the department at a moment when the internal investigation was still ongoing and when the department had not yet made any formal decision about what to do with the officer involved, which meant that when the video had been made available in response to the public records request, it had been made available in a context where no resolution had been announced, and where the contrast between what the recording showed and the institutional silence about that content had been immediately and widely noted. The reaction to the video had followed the pattern that recordings of that kind produce when the evidence is sufficiently clear, and when the central element of the scene contains something that transcends the usual divisions of who tends to align with which position in police conduct cases. The question about what Catherine was doing in that neighborhood had functioned in that recording the way the officer's question to Ayla at the IHOP had functioned in the body camera of that case, as the moment that condensed in explicit language the assumption that had motivated the entire interaction in a way that made it impossible for anyone watching to argue there was another interpretation available. There was not. The camera had captured an officer asking a black woman what she was doing in the neighborhood where she lived, and had captured that on a street whose large houses were visible in the background, and had captured Catherine's response saying she lived there, and had captured the officer's silence after that response. Any analysis that attempted to construct an alternative narrative needed to begin by explaining that specific sequence, and there was no available explanation that held up. Civil rights organizations had issued statements in the first 48 hours after the video's publication. Bar associations had issued statements. Judges' associations had issued statements, some with language that was unusual in its specificity, naming the officer and describing the behavior captured in the recording with a directness that that kind of organization normally avoids in public statements about individual cases. Elected representatives had called for independent investigations, And there was a category of reaction that had been perhaps more widely cited than any of those institutional statements, which was the reaction of attorneys and judges across the country who had shared the video, with comments that touched on a dimension that institutional statements did not fully capture, the dimension that what had happened to Catherine was what happened to black citizens who were not federal judges in similar situations, without a camera, without institutional position, and without the precise legal knowledge Catherine had applied in every second of that interaction. That specific angle had been what had given the case a resonance that went beyond outrage at the treatment of a federal judge, which would have been sufficient on its own, but that had created a broader conversation about what Catherine's experience revealed, about experiences that were not documented on body camera and were not conducted by people with the training to respond the way she had responded. Catherine had said in one of the few statements she had made during the period prior to the case's resolution that what had happened to her had happened because of who she was, and that there were people who lived the version without camera of that experience regularly without the resources to do what she was doing about it. That statement had circulated widely and had been cited with a frequency that indicated it had resonated in a way that longer and more elaborate statements frequently do not resonate, because it had said in 2 sentences what many longer analyses tried to say in many more words. The department had announced the conclusion of the internal investigation 28 days after the stop, which was also 16 days after the video had become public. The conclusion had been that the officer had violated departmental stop protocols by having no articulable justification based on objective observation before turning on the cruiser lights, had violated conduct protocols by asking questions that had no connection to any legitimate policing objective, and had escalated the situation disproportionately by calling reinforcements in a situation that had not justified the initial presence. The investigation had recommended dismissal. The director had agreed with the recommendation and had announced the officer's dismissal in the same statement that announced the investigation's conclusion, a timing choice that had been read as a signal that the department had decided that the speed of resolution was as important as the resolution itself. The civil lawsuit had been filed 2 days after the dismissal announcement, and the timing had been deliberate in the same way that the timing of several prior elements had been deliberate, as the result of a strategy that had been thought through from the first days after the stop, with an attention to detail that reflected what happens when someone with Catherine Morris's training and experience directs that competence toward a situation that had happened to them. The lawsuit named the officer individually, the department as an institution, and the county as the entity responsible for supervising the department, and had been constructed with a specificity that attorneys who analyzed it described as a document that had been prepared by someone who knew exactly what a judge looks for in a lawsuit, because they had spent 8 years being that judge. The agreement was signed 43 days after that Valentine's Day morning, at a speed that had surprised even the most experienced attorneys following the case, because lawsuits against police departments rarely resolve in less than 2 months, even when the evidence is clear, and even when the dismissal of the agent involved has already been announced. The speed had been attributed by people close to the negotiations to a factor that was simultaneously obvious and rarely articulated with that clarity. The county had assessed that each additional day without resolution was a day the video continued circulating. The department's name continued appearing in legal analyses and discussions about police conduct, and the distance between what the recording showed and any defensible narrative continued being the central element of every conversation about the case. The rapid resolution had not been institutional generosity. It had been calculation. The financial amount of the agreement had been substantial, confirmed by sources close to the process as being among the largest paid by the county in individual civil rights cases, with a specific component that had been negotiated at Catherine's insistence and that had not been seen in prior department agreements. A portion of the amount had been designated as a fund dedicated exclusively to training agents on stops in residential neighborhoods, with an oversight committee that included representatives from community organizations, and that had authority to approve the curriculum before implementation and to audit execution afterward. That condition had transformed part of the money the county had paid to resolve the lawsuit into a mechanism that existed specifically to reduce the likelihood that the situation that had generated the lawsuit would repeat itself, and had been described by civil rights specialists who analyzed the agreement as one of the most creatively constructed conditions they had seen in a case of that kind. The officer had been dismissed before the agreement was signed as a result of the internal investigation, and the dismissal had included a notation in the employment record that prevented rehire in any law enforcement capacity in the state. The union had filed an appeal that had been denied on second review after the arbitrator had watched the complete recording and had concluded in his findings that the question about what Catherine was doing in that neighborhood had no available operational interpretation that made it part of any legitimate police protocol, and that the absence of any observable justification for turning on the cruiser lights was documented by the agent's own body camera in a way that made the defense based on operational discretion impossible to construct without contradicting what was recorded on that camera. The union had attempted a third instance. It had been denied with language even more direct than the second. The institutional conditions of the agreement had been more extensive than the financial conditions in terms of pages negotiated, which was an indicator of the priority Catherine had given from the beginning to outcomes that existed beyond her individual case. There was a complete revision of stop protocols with documentable criteria that each agent would need to be able to articulate before turning on a cruiser's lights, not after the stop, as had been the case with the license plate angle justification, but before, with registration in the dispatch system of what the justification was at the moment the decision was made. There was a system of stop pattern analysis by agent and by geographic zone that would automatically identify statistical anomalies that could indicate systemic discriminatory behavior before individual cases reached the stage of formal complaint. And there was a condition that had been the most debated in negotiations, and that Catherine had described in one of her meetings with the attorneys as the most important of all. Any agent who asked a question during a traffic stop that had no articulable connection to the registered justification for that stop would be subject to automatic review without need for formal complaint from the stopped party. The case had produced consequences that spread beyond the county in ways that had become documentable in the months following the agreement. Departments in other states had revised their stop protocols citing Catherine's case as a reference. Law schools had incorporated the recording into constitutional law and civil rights courses as an example of documentation of a discriminatory stop with direct evidence. Police training organizations had developed curriculum materials based on the analysis of the 4 moments the internal investigator had identified as failure points, not because Catherine's case was unique, but precisely because it was not, because the patterns the camera had documented were patterns that existed in stops that were not recorded or that were recorded, but did not reach the level of public attention this case had achieved. Catherine had returned to the courthouse the day after the agreement was signed, had conducted the scheduled hearings with the precision of any other day, and had responded to the questions of journalists waiting outside the courthouse with a brevity that had frustrated some and that had been exactly right according to others. She had said the agreement was fair and that the institutional conditions were the outcome she had sought from the beginning. She had said the body camera had documented what it had documented and that the system had functioned the way it should function when evidence and determination are simultaneously present. And she had said, before going back into the courthouse, that the following morning she would drive the same car, down the same street, at the same time, because that was the way to work, and because no stop on a February day was going to change the route she took to work. She had entered through the court personnel access without looking back. At 10:42 the following morning, the white car had passed down the same residential street with the large houses and the trees still leafless in the late winter, and there were no cruiser lights in the rearview mirror, just the road.